And I think I'm going to take the time to read on the parliamentary record the extent of the changes that now have been made to the bill, so that there is a full appreciation of the appalling process that is actually happening here. This is not just the height of disrespect for the opposition and parliamentary process, it's the height of disrespect for the community. And given those statements that I read out that the member for Sydney had made on other debates in this House, it's the height of hypocrisy. It's absolutely the height of hypocrisy, because I can tell you this, I've been in this place for 12 years, for almost 10 years now. Yes, it goes by very. The member for Terrigal and I came in here together. He knows. For almost 10 years, I have never seen parliamentary process disrespected in this fashion by not supplying amendments, particularly amendments on what the member for Sydney contends is very important legislation. I mean, when I was a barrister, you would not be able to provide substantial amendments like this on no notice when you're about to start arguing a case. The courts would not allow it. Correct. The transparency of process is actually really important, whether it's in our courts or whether it's in our parliaments. And indeed, I doubt that any workplace in the country would allow people to operate in that fashion with such disrespect to their colleagues as the Minns Labor government, because they've clearly had these amendments before they were supplied to the opposition. And the member for Sydney has performed in this fashion. And can I just make this very clear? Because the new document that was supplied to us and the public after 12:15 p.m. today has a number on it, the new number is C 2024-115 capital V. That means that between Saturday night and today, there have been 15 further changes to the document which were never supplied to the opposition. And that this is the 15th version. We only get the 15th version, apparently, when I'm about to get up and give a speech in reply on behalf of the opposition with no ability to actually properly address the changes that have been made. And of course, there's something else that is wrong about the process here, and it's not just about time. It's also about the fact that the opposition is not given an opportunity to actually consult with the community, to actually to formulate a position with proper consideration. And so the other point is that when the original bill was introduced back in August of last year, the second reading speech really didn't explain word by word all the provisions as we usually hear in a second reading speech, and an explanation for why each of them were being put through. And with all of these now further iterations of the bill, with all these amendments that seem coming almost by the minute, where actually we don't get the benefit of the member for Sydney to actually get up in Parliament and explain to the members of Parliament and the public what are the reasons for the further changes and what is motivating them and why they are being made. So there couldn't be a situation where the process has been more calculated to disarm proper transparency, scrutiny and debate about provisions. And can I just say this further matter which I've left out with regard to process, and that is that in accordance with ordinary parliamentary processes, the debate for this bill should have happened tomorrow. Yeah. It should have happened tomorrow on Thursday, which is Private Members' Bills Day. Now, do you know when the opposition was actually told that the matter would be on today? At 9:30 a.m. this morning was the first that anyone told us. The member for Sydney or the Labor government, the Leader of the House, that was the first time we were ever told. We were ever told that this debate would come on today. So that's the process. That's the process. Yes, the member for Sydney has now left the chamber. But I do want to say this thing. The member for Sydney chose to personally attack me today in the media. And I'm going to say this. I'm not going to personally attack him. I always remember that our great Premier Gladys Berejiklian used to say, when people go low, I always go high. And I'm not going to make this... I'm not going to make this a personal debate.
Order. Thank you.
A personal attack.
Member for Newtown. Thank you.
I am interested in raising matters of process and the standards that the member for Sydney has previously stated as appropriate, and to say this is a process which is terrible and should not have taken place. Now, I'm now confronted with the prepared speech, which I worked late into the night to prepare, on a bill which apparently is going to be different to the one that we were notified of late on Saturday night. But I'm going to talk about the amendments that we were supplied with on Saturday night, and then I'll try and deal with the further amendments that have been put up for the first time, the further extensive amendments that were put up for the first time at 12:15 p.m. today, just less than an hour ago, and certainly I can tell you, Madam Speaker, I was only made aware of these changes literally at the time when the matter to be accorded priority had finished and this matter was called on for debate. Now, Schedule 11 of the bill as amended with the amendments that we were notified on Saturday night seeks to repeal Sections 15 capital A and Section 15 of the Summary Offences Act. Now, the reason for deleting these provisions were given in the second reading speech by the member for Sydney as follows, quote, "There is an offence for knowingly living off the earnings of sex work with adults living with a sex worker who do not have other sufficient lawful means of support specified. The offence could incriminate a sex worker's partner who becomes incapacitated, an adult child who lives at home while studying, or a housemate on a low income, exerting coercive conduct or undue influence to, quote, cause or induce, close quote, someone to commit an act of prostitution or surrender any proceeds from it is an offence. The offence creates complications and risks for sex worker businesses in recruitment, sex workers talking about their work with friends, and support services helping a person starting with sex work. The offence does not address sexual servitude, which is addressed in the Criminal Crimes Act." Now, Section 15 capital A of the Summary Offences Act, which Mr Greenwich notified us on Saturday evening he sought to repeal, has an offence for a person who causes or induces prostitution. A person must not, by coercive conduct or undue influence, cause or induce another person to commit an act of prostitution. That's subsection 1. Subsection 2 is a person must not, by coercive conduct or undue influence, cause or induce another person to surrender any proceeds of an act of prostitution. Now, the maximum penalty is imprisonment for 12 months or a penalty of 50 penalty units. Coercion can be physical or psychological. It can be done by violence or threats and intimidation. Undue influence is a doctrine which started in the law of equity, which means that a person did an act under such circumstances as to show or give rise to findings that the person has not been allowed to exercise a free and deliberate choice about a matter. None of the arguments advanced by the member for Sydney in his second reading speech even approaches any behaviour or circumstances that could justify the repeal of this section so as to justify persons coercing or using undue influence on another person to commit an act of prostitution or surrender the proceeds afterwards. In the second reading speech introducing this provision on the 19th of October 1995, the then Labor Attorney General, the Honourable Jeff Shaw QC, said that Section 15 A, quote, would include, for example, the offering of heroin to a heroin addict so that he or she engages in an act of prostitution. This provision is also capable of ensuring that the exploitation of young women in particular does not result from the recognition of brothels as legitimate commercial enterprises, end quote. Can I just say on behalf of the opposition, there's never any justification for coercing or exerting undue influence on a woman to do something against her will, like prostitution, and to profit from it. This is a disempowerment of a woman's agency to make decisions about what she does and does not do with her body. And can I just add that the section applies equally to men, women, or trans people being coerced or undue influenced. There is nothing in an LGBTI equality bill that would suggest that provision should be repealed, as the member for Sydney informed the opposition on Saturday night that he intended to do. Are we having a lunch break?
Keep going.
Oh, no, okay, all right. The examples given in the second reading speech by the member for Sydney...
Can I just interrupt and
Yes.
say we are working through lunch too, so just to let you all know. So, beg your pardon.
The examples given in the second reading speech by the member for Sydney about dependent adults, or that it could criminalise casual conversations with people wanting to start in the sex industry, are nothing like the kinds of behaviour that are covered by the terms or by the law of coercion or undue influence. I would challenge the government or Mr Greenwich to produce a single reputable legal advice to suggest that these examples could amount to coercion or undue influence as the case law understands them. I cannot believe that the Premier of this state got up and said he supports Mr Greenwich's amendments and would support an amendment to allow the coercion of women into prostitution by threats and intimidation without any criminal sanction, as we were notified on Saturday night was the intention of Mr Greenwich in this bill. Indeed, it's ironic that the Minns government has cheered on the commencement of the operation of the former coalition government's coercive control legislation, which commenced on the 1st of July of this year, introduced by the Crimes Legislation Amendment Coercive Control Act of 2022. That criminalising of intimate partner coercive control involved control by an intimate partner. Why is that of a different character to the Summary Offences Act provision? Why does the Minns government want to support Mr Greenwich's legislation that turns a blind eye to coercion of women into prostitution by people who are in a commercial relationship with the person? The member for Sydney, Alex Greenwich, seems to be similarly confused because in Schedule 5 of the bill, with the amendments supplied to the opposition on Saturday night, in Clause 2 of Schedule 5 of the version that we got on Saturday night, he wants to include in the definition of coercive behaviour somebody who threatens to out a person's sexual orientation. But yet, with regard to the Summary Offences Act, he wants to take away any criminal sanction for somebody coercing a person into prostitution. These were the sorts of matters that we have been confronted with by the document that was supplied on Saturday night, and we haven't been told anything different before 12:15 today. In a debate that we only got notice of at 9:30 this morning, that it was going to be brought a day early. Now, the New South Wales Government's submission to the parliamentary inquiry on the proposed changes also agreed that the repeal of sections 15 and 15 capital A would take away protection of sex workers from exploitation. Now, section 15, which I'll now go to, so I've started with section 15 capital A. Section 15 of the Summary Offences Act, which also Mr Greenwich seeks to amend, is in the following terms. 1, a person shall, it's got a heading, living on the earnings of prostitution. 1, a person shall not knowingly live wholly or in part on the earnings of prostitutions of another. Maximum penalty, imprisonment for up to 12 months and a fine of 10 penalty units. For the purposes of subsection 1, a person who is of or above the age of 18 and who A, lives with or is habitually in the company of a reputed prostitute, and B, has no visible lawful means of support, shall be knowingly taken to live wholly or in part on the earnings of prostitution of another person, unless he or she satisfies the court before which he or she is charged with an offence under the subsection that he or she had sufficient lawful means of support. So it's a kind of unexplained wealth provision, because the legislation recognises that it may be hard to prove coercion and that someone is actually coercing someone into prostitution, but if they've got unexplained wealth, they're obviously living off the proceeds of prostitution, which is taking advantage of very vulnerable people within our community who are engaged in prostitution. Now, subsection 3 says a person does not contravene subsection 1 by living wholly or in part on earnings derived from a brothel, or if the person owns or manages or is employed by the brothel. And subsection 4 says, for the purposes of subsection 3, premises may constitute a brothel even though used by only one prostitute for the purposes of prostitution. Now, living wholly or in part on the earnings of prostitution of another person is taking some or all of the earnings at or shortly after the act of prostitution. The people who criminally do this are colloquially known as pimps and usually coerce prostitutes by various means difficult to prove into being a prostitute. Living on the earnings of prostitution has nothing to do with a prostitute voluntarily sharing their earnings with a dependent adult child or a housemate, which were the examples given by Mr Greenwich in his second reading speech. In introducing subsections 3 and 4 of section 15 into law, the second reading speech on the 19th of October 1995 by the then Labor Attorney General, the Honourable Jeff Shaw QC, said that, quote, living off the earnings of prostitution requires a continuous association with the prostitution industry and habitual receipt of money from the earnings of prostitution. None of the domestic relationships cited by Mr Greenwich in his second reading speech constitutes a continuous association with the prostitution industry. There is not a business character to the domestic relationships that he uses in his examples to justify the amendment. There's no association with the industry because their receipt of money is by reason of a voluntary payment and has no commercial character in association with the industry of prostitution. It would be like saying my children, when they were living at home and under the age of 18, lived off the proceeds of Parliament, under his analogy. I mean, it's just ludicrous. And Mr Greenwich doesn't point to one case or decision in a court of this country consistent with his rather absurd interpretation of the section and what it means to live off the proceeds of prostitution. The way to achieve his stated justification would have been to create an exception to the section to cover the instances that he was concerned about, but to keep the criminal protection of vulnerable people from being commercially exploited. But instead of doing that, a complete repeal of the section was proposed in the amendments supplied to the opposition on Saturday evening. It is not justified and should not be supported. And again, the provisions protect men, women and trans people equally. And it's strange to see that protections of that kind would be taken out of a bill that is a so-called LGBTI plus equality bill. And to think that, again, that the Premier and the Minns government are supporting the decriminalisation of exploitation of vulnerable men, women and trans people is difficult to fathom. And maybe that's why they don't want full transparency, and the process has been so bad. Now, the next matter that I want to go to is the question of birth certificates. Which is in Schedule 1 of the bill as amended by the 79 amendments supplied to us on Saturday evening. And it deals with changes to the Births, Deaths and Marriages Registration Act, and in particular to the sex recorded on the record of a person's birth. Now, I want to say from the outset, when the Coalition was in government, we didn't repeal provisions protecting gender diversity or trans people or so on, which are in the Anti-Discrimination Act and otherwise. Indeed, we introduced provisions that recognise and protect such people. For example, we introduced Section 93 Z into the Crimes Act. That creates an offence of publicly threatening or inciting violence on the grounds of race, religion, sexual orientation, gender identity, or intersex, or having HIV/AIDS status. We created a criminal offence where if a person, by a public act, intentionally or recklessly threatened or incited violence towards another person or a group of persons on a number of grounds which included sexual orientation and gender identity, and we had a maximum penalty of 3 years imprisonment and $11,000. So our position on these matters is not motivated by any lack of tolerance for diversity. It is because of the matters which I will raise in the second reading speech to do with this omnibus bill. A bill which on the version that we were given on Saturday evening had 13 schedules and amended 12 pieces of legislation and one set of government rules. Now, the opposition to the changes proposed are motivated by a consequence of the many unanswered questions as to the implication of these rush changes which are being put before Parliament. And I want to raise a few matters. The existing Part 5 A of the Births, Deaths and Marriages Act provides for a process whereby a person born in New South Wales over the age of 18 or the parents or guardians of a child may change the sex of a person on their birth record. They can do this after having a sex-affirming surgical procedure involving the alteration of a person's productive organs to help a person be considered a member of the opposite sex under sections 32A and section 32B of the existing law, so long as the application is accompanied by a declaration by a registered medical practitioner under section 32C. But the version of the bill that we were supplied with on Saturday night wants to change these provisions in a manner which the Coalition finds to be too low a threshold and by procedures that it does not find adequately protects minors and families. The possible implication of these shortcomings is significant. Sex is a biological descriptor based on reproductive, hormonal, anatomical and other objective criteria. Gender is an individual's sensitive sense of subjective sense of what sex they are and is not necessarily visible to others. The outcome of this bill will be that the meaning of somebody's legal sex under the Birth, Deaths and Marriages Act will change from an objective test to a subjective test like their gender, and these two are not the same. Revenue New South Wales correctly states on its website that the primary identity document in Australia is an Australian birth certificate issued by the Registry of Birth, Deaths and Marriages, An Australian birth certificate issued by the Registry of Births, Deaths and Marriages is the only acceptable document for identity. And for overseas, the identity document is a passport. As I've already explained, currently birth certificates in New South Wales identify a person's sex, which is an objective criteria, and passports indicate gender by a subjective criteria of gender. On the Australian Government DFAT website, this is made clear. It states that on your passport, we, DFAT, record your preferred gender in the sex field of your Australian passport. The gender options are male, female, or X, non-binary, intermediate, intersex, unspecified, other. The Premier's public statements this week that a birth certificate and a passport should not be different as to sex appears to not understand the difference between the two, and that one is based on sex and the other is based on gender. The Alex Greenish bill, which is being supported by the Minns government, proposes a new administrative process to change the sex on a birth certificate record for people born in New South Wales, which does not require any medical or surgical intervention. In addition, contrary to some statements in the media recently, people can change their name under the existing Part 5 of the Births, Deaths and Marriages Act without any medical or surgical intervention. It's a completely false narrative to say that that surgery is required to change your name if you are trans. You can do it under Section 5 without surgery. The proposed bill introduces for the first time the possibility of a registration of a, quote, sex descriptor, close quote, other than male and female under the proposed Section 32, capital A definition that we were supplied with on Saturday night. For a person 18 years or more of age born in New South Wales under the proposed Section 32, capital B, supplied on Saturday night, the process requires an application in an approved form with a statutory declaration by the person stating that they identify as the nominated sex descriptor and live or want to live as another sex, with a statement in support by another adult who have known them for more than 12 months. For a person under the age of 18 born in New South Wales, under the proposed Section 32, capital C, supplied to us on Saturday night, the sex descriptor on their record may be changed by an order of the District Court after an application by the minor alone, supported by a qualified counsellor. No statutory declaration by the minor is required. The court may, but may not, if the applicant convinces it otherwise, notify and seek the views of the parents or other persons with parentage responsibility for the child about the application to change their sex. The qualifications required by a counsellor under the proposed Section 32, capital A that we were supplied with on Saturday night are not stated in the legislation and will be determined by regulation. The parents or guardians, if they are all in agreement, may apply administratively to the Register of Births and Deaths under the proposed Section 32, capital D of the bill, to change the sex descriptor of the child. In this case, unlike an application by a minor under the proposed Section 32, capital C, supplied on Saturday night, a statutory declaration by the child is required under Section 32, capital D, supplied on Saturday night, when supported by the parent or guardian that the minor identify as being of the sex descriptor. If the parents or guardians do not all agree, they must apply to the district court to change the record of sex descriptor under the proposed section 32 E supplied on Saturday night. Similar provisions relating to Australian or internationally born persons who are not born in New South Wales to change their sex descriptor are included in the proposed Division 4 of the bill that was supplied on Saturday night. The proposal has raised significant community concern because the practical effect is that persons with the sex of a man who identify as a woman may, without any surgical change to their bodies, legally become a woman on their birth certificate and are likely to have, therefore, greater access to female-only spaces such as swimming pool changing rooms, showers, play female sport, attend female refuges, female prisons, and so on, in a manner that they currently do not have the legal right to do. If a trans woman has a female birth certificate under these new proposed provisions and has undergone no medical, like hormone treatment or a surgical process, then it will become difficult and perhaps in breach of Part 3A of the Anti-Discrimination Act to treat them as anything other than female. Legalities aside, it will be very difficult from a practical point of view to go behind a birth certificate that says that a person is a woman. This could all create significant issues for single-sex schools, including boarding schools, women's refuges, and there are overseas and interstate examples where it has created major problems and risks in female prisons. And I might say that I was joined in a press conference today with an extraordinarily broad alliance of members of the community who are concerned about these issues. With all the trouble in the world today, representatives of the Muslim faith, the Jewish faith, the Christian faith, Hindus, Buddhists, many of them are concerned. Multicultural leaders are concerned. We had representatives of lesbian groups with us who are concerned, including one who considers herself, who is a member of the Labor Party, considers herself extremely left-wing, and who opposes these changes. Now, in an Orwellian twist, in the proposed section 32 H, which we were supplied with on Saturday evening, it states that any change to the sex record under this part means a person is legally of the sex that has been changed. However, a note in the section, which is of no legal effect, states that, quote, nothing in this part changes access to toilets, change rooms, sport, allocation in commercial facilities, women's refuges, or any other place, end quote. Now, Section 35 of the New South Wales Interpretation Act specifically says that notations like this shall not be taken to be part of the Act. Not only do the operative provisions provide to the contrary of the notation, but the notation also, interestingly, doesn't mention specifically schools or marriage ceremonies, which are two of the concerns about the practical implications. One of the practical concerns raised by has been the impact of the bill upon religious freedom. One concern raised is how will churches know they are not marrying two people which their religion regards as men, contrary to their faith, when one appears as a woman, has a changed birth certificate to state they are a woman, but physically they are two men and are considered men by that religion. Indeed, it's been suggested that the marriage itself could be invalid because the civil marriage's validity depends upon a proper religious marriage. Similar considerations may apply to single-sex private religious schools. Now, under Mr Greenwich's document provided on Saturday night, and contrary to press statements made by him, parental consent is not required under the proposed section 32 C for minors to apply to the district court for changes to their record of sex descriptor, and they may be excluded from the decision-making process and indeed knowledge of the application. Because a birth certificate is a person's primary identity document, there are also concerns with the manner in which the bill specifies that any changes must not indicate on a person's record any alteration of a person's sex, sex descriptor or person's name under sections 32 F subsection 5 and 32 G subsection 5 supplied to us on Saturday night. This effectively means that a new identity is created. The possible implications for law enforcement and fraud require consideration and investigation. Subsection 32, subsection 5, subsection 32 F, subsection 5 subsection B, and 32 G subsection 5 subsection B do not appear to match the other changes made to the original bill. This was averted to in the New South Wales Government's submission to the parliamentary inquiry on the proposed changes. The Government's submission said relevantly, quote, "The New South Wales Government has identified a number of areas in which the proposed amendments to the Births, Deaths and Marriages Act do not align with other provisions of the Births, Deaths and Marriages Act, pose operational issues or may allow for the exploitation of the birth registration system," end quote. The submission also stated that the absence of a procedure for the applicant to request a copy of a birth certificate that shows a person's previous registered sex is inconsistent with section 32 F of the Act, which allows a child of a person whose sex has been altered or a person prescribed in the regulation to apply to the registrar for a birth certificate that shows the person's sex before the record was altered. Another strange aspect of the 79 amendments made on the weekend that we were supplied with is that the narrative by the Premier that he supports the bill is because people's names should not be different on different identity documents. The Premier conflated, as I've already said, a birth certificate which states a person's sex with a passport which states a person's gender. But the different name justification seems to have been undercut by the 79 amendments delivered on the weekend. Originally, the bill allowed for a process within the proposed new Part 5 A of change of sex to also include a change of name at the same time. But part of the 79 amendments on the weekend was to take out the possibility of a name change as part of the same process as a sex descriptor record change. This means that a person changing their sex record will have to go through a different process under the Births, Deaths and Marriages Act under Part 5 to change their name. So the Premier was telling the public that it's all about just keeping consistency of names and people shouldn't have to have surgery, change their names, but he actually took out the process to change your name at the same time you want to change your your sex descriptor as it was originally provided in the bill. When the Parliamentary Committee surveyed the public with regards to the changes in the bill, 13,258 people responded and over 80% of respondents opposed them. The changes that have been made with the 79 amendments to the bill are unlikely to change that result. There are other curiosities which suggest that these provisions have not been drafted by the member for Sydney with care. For example, under the proposed section 32 B supplied on Saturday night, a person over the age of 18 needs to sign a statutory declaration in support of a sex change. Under the proposed section 32 D subsection 2 b, A person under the age of 18 with their parents' or guardian's support must sign a statutory declaration if they want to identify as another sex. But if a person under the age of 18 makes an application under the proposed section 32C without their parents' consent, there's no statutory declaration required at all. Why would that be different if it wasn't the product of a rushed, ill-considered process that has produced the documents that we were supplied with on Saturday night? The absence of any formality in the situation where the person is most vulnerable, that is, they're making an application without any support from their parents or guardians under the age of 18, is the only one without a statutory declaration. Doesn't make sense. I'm now going to move to surrogacy. Currently, it's an offence under Section 8 of the Surrogacy Act 2010 to enter into a commercial surrogacy arrangement punishable by a $110,000 fine and 2 years imprisonment or both. According to the Australian Government website Surrogacy Overseas, Surrogacy in Australia, entering into an international commercial surrogacy arrangement in New South Wales is illegal and carries risks for the surrogate mother, the commissioning parents and the child. The 2018 statutory review of the Surrogacy Act 2010 did not recommend any of the changes contained within the bill proposed by the member for Sydney. The New South Wales Department of Communities and Justice is currently undertaking a review of the Surrogacy Act 2010 where it is consulting stakeholders. Any changes to the Surrogacy Act should sensibly await the outcome of that review and should not be a piecemeal exercise of the kind proposed by Mr Greenwich's now further amended bill as supplied on Saturday evening and before I've even had a chance to look at the further changes. The New South Wales Government submission to the Parliamentary Inquiry agreed that the review process may be that it was undertaking, that is the Department of Communities and Justice was undertaking, may be the most appropriate avenue to consider amendments to the Surrogacy Act because of what it said was the complexity of the policy and operational landscape. That was the government's own submission. Schedule 12 of the bill, as supplied to us on Saturday evening, contains the proposed changes to the Surrogacy Act. In his second reading speech, Mr Greenwich identified that there are mixed views on commercial surrogacy. The bill proposes to remove the geographical nexus for offences, allow for easier parenting orders and, somewhat curiously, the change to the bill at clause 4, changing section 26, subsection 3 of the current Act, would allow for parenting orders with regard to people over the age of 18. Now, parenting orders are only made with regard to minors, not adults. And Section 4 of the Surrogacy Act defines a parenting order as an order made by the court under this Act for the transfer of the parentage of a child. So Mr Greenwich wants to make parenting orders for adults when the Act actually says they only apply to children under the age of 18. Now, in the second reading speech, Mr Greenwich said that the changes is to facilitate adult children being recognised for legal purposes like wills and powers of attorney. But he can't do that through parenting orders which are only allowed in the Act for minors. This is another example of a rush provision in this bill that doesn't make legal sense. The proposed changes represent a major policy change in our approach to commercial surrogacy. The New South Wales Modern Slavery Commissioner has raised concerns about this proposal. In response to concerns raised by the Modern Slavery Commissioner, Mr Greenwich has suggested in the media that going forward there will be limits to prescribed jurisdictions, quote, where commercial surrogacy is well regulated and the rights of the surrogate protected, close quote. One assumes he's talking about perhaps North American jurisdictions. But that statement by Mr Greenwich is not reflected in the amendments that were served on the opposition on Saturday evening. There seems to be an acknowledgement by Mr Greenwich that about the issue of slavery, but nothing was done in the document that was supplied to the opposition on Saturday evening. Now, before I conclude, I need to deal with the document as heavily changed at 12 o'clock today. So I'll just read that the document that was supplied at 12 o'clock today inserts a completely new amendment number 1. It inserts a completely new amendment number 3, which relates to the Births, Deaths and Marriages Registration Act changes. It is impossible for me, unless I sit down with the bill and read out the section on the Hansard and do it on the run, to actually say what those changes are. This is all, I'm reading, for the purposes of Hansard, I'm reading with regard to the document, the proposed amendments identified as C 2024-115 capital V, which I assume is now the most recent version of amendments that are proposed to Mr Greenwich's bill. Amendment number 10 has again changes to the Births, Deaths and Marriages Registration Act, which are inserted, Amendment number 11 makes further changes to the proposed changes to the Births, Deaths and Marriages Act. These are all changes from the version we were supplied on Saturday evening. Amendment number 12 now makes further changes to the amendments to the Births, Deaths and Marriages Registration Act. Of which it's impossible for me as the Shadow Attorney General to address on the run. Amendment number 25 makes new additions to the amendments to the Births, Deaths and Marriages Act from the amendments that were supplied on Saturday evening. Amendment number 26 provides further changes to the amendments to the Births, Deaths and Marriages Act changes that were supplied on Saturday evening. Amendment number 30 makes further changes to the Births, Deaths and Marriages changes that were supplied to the government, to the opposition on Saturday evening. Amendment number 34 makes further new additions to the changes that were supplied on Saturday evening with regard to the Births, Deaths and Marriages Act. Amendment number 41 provides further changes to the amendments supplied on Saturday evening with regard to the Births, Deaths and Marriages Act amendments. Amendment number 43 provides for a whole amended, it would seem, Division 5 capital A of the Births, Deaths and Marriages Act, at least in respect of new section 32 capital GA, a new section 32 capital GB, a new section 32 capital GC, these are capital Gs and capital Cs, a new section 32 capital G capital D, a new section 32 capital G capital E, a new section 32 capital G capital F, a new section 32 capital G proposed to be inserted within the Births, Deaths and Marriages Act. Now, amendment number 44 has further changes to the Births, Deaths and Marriages Act than was supplied on Saturday evening. Amendment number 45 has further changes to the Births, Deaths and Marriages Act than was supplied to the opposition on Saturday evening. Amendment number 46 has further changes to the Births, Deaths and Marriages Act amendments supplied on Saturday evening. I'm sorry for the tedium, but I think it's important for the House to understand this. Amendment number 47, Amendment number 48, Amendment number 49 all make further changes to the Births, Deaths and Marriages Act amendments that were supplied on Saturday evening. And that's not all. Amendment number 51 makes new changes to the Children's Guardian Act changes. Amendment number 53 makes new changes to the Crimes Act amendments that were supplied on Saturday evening. Amendment number 55 makes substantial changes to the Crimes, Domestic and Personal Violence Act. These are important provisions with regard to apprehended domestic violence, which we are seeing for the first time, and members of this House are seeing for the first time at 12:15 p.m. today. Absolutely incredible. The arrogance of the Minns government to bring this on in these circumstances, and frankly, I'm not going to get personal, but it is the Minns government that has allowed this to come on, and I think it's important to acknowledge that. Further amendments, new amendments in amendment number 57 to the Government Sector Employment General Rules. Amendment number 58 has new changes to the Interpretation Act from the ones that were supplied as the amendments on Saturday evening. Amendment number 59 has new changes than those given on Saturday night with regard to the Law Enforcement Powers and Responsibilities Act. Amendment number 61 has changes to the Summary Offences Act that I've spoken about. That would appear to be to repeal the criminalisation of living off the earnings of prostitution. But someone has twigged that what I was saying about coercion was absolutely spot on, and Section 15 A has now been changed from the version we gave on Saturday evening and is not to be repealed. I suppose at least that's good news for the people of New South Wales and for vulnerable men, women and trans people in New South Wales. Amendment number 62 makes substantial further changes to commercial surrogacy from the version that was supplied to us on Saturday evening. And when I say substantial, I'm talking about the number of provisions. Sometimes the other changes that I've identified might be only to a section or some words, but may have profound implications, which of course we are not in a position to address in the way that this has come forward. Amendment number 62 has further changes to the Surrogacy Act than were provided on Saturday evening to the opposition. Amendment number 64, further changes to the Surrogacy Act than were supplied to the opposition on Saturday evening. Amendment number 65, further changes to the Workers' Compensation Act than was supplied on Saturday evening. Amendment number 66, again seems to change another provision with regard to the Workers' Compensation Act from the version that was supplied on Saturday evening. Madam Speaker, what I'm going to ask is leave to table a document which has been quickly prepared, which actually demonstrates in red matters that have been omitted from the version C 2024-115 capital G of amendments that were provided on Saturday evening, and the version C 2024-115 capital V, which has been only made available now at after 12:15 today. I'm going to cross out some of my scribble and some things, which doesn't need to be part of the Hansard and all the documents of the Parliament. But I think it is important.
Can I just interrupt and
Yes.
respond to you?
Yes.
After consulting with higher forces in front of me, Standing Order 271 allows a member to seek leave of the chair to incorporate materials into Hansard, and that's given in circumstances where material cannot be readily explained or read onto the record. Yes. If you consider that it's...
Well, I could take 5 hours and I have an unlimited amount of time
sure.
if I don't need to do it, but I would prefer leave.
I think that
I'd like it to be in Hansard if that's possible.
Sure. Well, as far as I'm aware, from this position, I think that that's totally
and if I can just explain again, the matters marked in red, I don't think in the circumstances of the behaviour that's gone on that's appropriate. The matters in red are omissions from the version supplied on Saturday evening. The matters in blue are new additions that have come in the version that has been made available today after 12:15. And green are movements of, I believe, provisions that were there on the version that was provided on Saturday night in a different position but not a change. So there are 3 different colours identifying 3 different things. I must indicate, Madam Speaker, I didn't prepare this document. I haven't had a chance to check its accuracy, but others have done it, and I'm assuming that it is accurate. If there are any changes, if there are any corrections, I think it's important it goes in the parliamentary record. If there are any corrections, I believe that our colleagues in the upper house will have the opportunity to correct that, because I do not believe in the time, given the way in which the upper house has been told that this matter will be dealt with tomorrow morning, that it's going to finish in this house today, and it's going to be impossible, I think, to go through line by line and double check everything. As a diligent Attorney General, Shadow Attorney General, I would ordinarily do. Can we get another copy of this? Yeah. Hang on. Sorry, just one moment. Sorry. So I will. I'll provide this document, and as I said, if there are any corrections to be made, I think they can be made in the other place. It may be the only copy that we have of that document at the moment, so I wonder if maybe I could prevail upon the parliamentary staff to make a copy as well. Now, Madam Speaker, in conclusion, after lying dormant for 14 months, all of these amendments to the original bill are now being rushed through Parliament with inadequate notice and an extremely rushed fashion. Last night, I must say, I was troubled that the version we had been supplied with on Saturday night was not yet up on the parliamentary website and had been tabled. So even the document that we were supplied with on Saturday night was not a publicly available document. It had certainly been drafted by the Parliamentary Council, so it had a degree of verisimilitude, having been supplied by the member for Sydney and us being told that it would be his version of changes. But it did concern me that the public were not available to see these changes and to converse with their elected representatives. I've already said that I consider this very disrespectful, the process. And indeed, when social policy is changed, there should be proper transparency, that it be in the best interest of the public. And I must say, that is in the interest of the people who are moving these changes, so that the public can be confident that a proper process has taken place, and then that gives the provisions authenticity and authority. But when the processes have been so perverted as they have been in this case, I think it's very important to draw attention to these matters, because they have real impacts on the way in which parliamentarians can properly legislation and make laws in this place. From what we have seen, the bill doesn't get the balance right with regard to the issues that I've raised. Accordingly, the opposition, who at all times have been acting on the basis of the amendments supplied on Saturday evening, will oppose this bill. Now, I'd like to conclude by just thanking the many people who have contacted their members of Parliament in the opposition to give their views on the bill. And I think I'm correct in saying that the overwhelming majority have expressed concerns about this legislation, and I hope that my speech has given some light to why they would have some concerns about this omnibus bill. I'd like to specifically make a few call-outs to some of the people who have met with me in my capacity as Shadow Attorney General. This is by no means an exhaustive list, but I would like to acknowledge Melissa Skalski from the Australian Collective Rights Group. I'd like to thank Virginia Mansell-Lees and Bronwyn Winter from the Coalition of Activist Lesbians. I'd like to thank Michael David and others from the LGB Alliance. Many of the religious leaders, I want to thank Sheikh Shady Al-Sulaim.
Yeah, that's right.
Is that okay? Bishop Michael Stead, Surinder Jain, Jain, I'll give you a list. I'm sorry, who is involved in the Hindu Council, but he's also one of the co-presidents of Better Balanced Futures. Darren Bark from the Jewish community, who's the other co-president of Better Balanced futures. We've got we have, as I've said already, Muslims, Jews, Christians, Buddhists, Hindus, all united against this legislation. I should also just acknowledge that today we had a number of other people who on very short notice came and attended a press conference which I had, and who were, some of whom had the opportunity to express their concerns about the bill. They included not only my colleague, the Honourable Susan Carter from the other place, but also Bronwyn Winter from the Australian Feminists for Women's Rights group. And Bronwyn was the lesbian Labor Party member from the left of the Labor Party who says that she had been unable to get any engagement from the Labor Party about her concerns on the bill, and that she was very concerned about the bill. Vivian Morrigan from the Coalition of Activist Lesbians was there today. Monica Dermott, who was the Director of Public Affairs and Engagement at the Catholic Archdiocese of Sydney. Surinder Jain, who I've already mentioned, was there today, as was Bishop Michael Stead. Reverend Emma Little from the Anglican Church, and Reverend Kamal Weerakonn, W-E-E-R-A-C-K-O-O-N, from the Presbyterian Church. We have Murray Norman, the CEO of Better Balanced Futures, and Vanessa Cheng, who is the Executive Officer of the Australian Association of Church Schools, were all in attendance. Some of them had the opportunity at the press conference to give their concerns about the bill. I hope, Mr. Speaker, or Speaker, that we can hold a respectful debate. I was very troubled by the personal attacks by the member for Sydney against me. This is not personal. This is actually representing concerns of the community, and it shouldn't be the case that if you have policy differences with someone that they personally attack you. You know, I think the members of the public expect better from their members of parliament than that, I've been able to draw together what I think is a chronology which is troubling, and which I consider represents a lack of respect for the opposition. But that's not a personal attack, that's just a reflection on the process and the way in which this matter has moved, and the previous promises that were given to us about seeing the amendments in plenty of time. I think, Mr. Speaker, I have said everything that I can say at this point in time, but I will just reiterate that the opposition will be opposing this bill.
I thank the member. The question is that the bill be now read a second time. I call the member for Newcastle.
Thank you, Mr. Acting Speaker. I rise to speak in support of the amendments to the Historic Equality Legislation Amendment Bill 2023. And I will just start by saying that the member for Wahroonga has a very, very short memory. As a co-sponsor of the Voluntary Assisted Dying Bill, I remember that the member opposite, as Attorney General, dropped 60 amendments. 60 amendments on the lap of the member for Sydney and the co-sponsors just moments before the debate was about to begin. Just thought I'd mention that. The member's obviously forgotten. Bit of convenient amnesia, hey? Bit of convenient amnesia up there by the member opposite. What hypocrisy. But to the amendments. Newcastle has a long-standing history as a progressive and inclusive city that continues to drive for greater support for our LGBTQI+ community. The 2017 legal marriage plebiscite indicated Newcastle's overwhelming support for the LGBTQIA+ community, with 74% of Novocastrians voting in support of legalising same-sex marriage. At our recent local government elections, in a monumental moment for Newcastle, we elected Labor Ward 2 councillor Paige Johnson, the first openly transgender woman elected to public office in New South Wales, further reaffirming Newcastle's stance as an inclusive city for the LGBTQIA+ community. As the Vice President of the Hunter Gender Alliance, Paige has been steadfast in advocating for the rights of trans and gender diverse people in the Hunter region and is committed to continuing her advocacy work in this space. I also want to acknowledge the contribution of Hunter Rainbow Labor, and in particular Paige Johnson, Declan Clausen and Stephen Moore for their contribution in the consultation on these amendments. The growing voices of LGBTIQA+ advocacy groups within the Hunter in recent years emphasises the need for greater recognition and legislative change, such as these amendments here today. ACON Hunter is one of our leading health organisations specialising in community health, inclusion and HIV responses for people of diverse sexualities and genders. Recognising that members of Australia's sexuality and diverse communities experience health disparities when compared to health and wellbeing outcomes experienced by the total population, ACON Hunter works tirelessly to reduce the stigma around LGBTIQA+ health. These amendments, which will update the terminology in the Drug Misuse and Trafficking Act to replace terms such as HIV infection and suffering with AIDS to living with HIV/AIDS, will significantly help organisations such as ACON in providing support and services to our local community and those across New South Wales. Another organisation making great strides within this space is the Hunter Gender Alliance, which works to improve health, rights and lives of transgender, gender diverse and non-binary people within our region. Both ACON and the Hunter Gender Alliance have been steadfast in championing for more inclusive laws. We, the government, support the hard work of these organisations today, including amendments to the Birth, Deaths and Marriages Registration Act to enable a person to change the record of their sex on their birth certificate without the need to have surgery, and the Mental Health Act to prove that a person is not mentally ill or mentally disorientated. This is a fitting time for these amendments. This month in Newcastle, there are many events taking place to celebrate our LGBTIQA+ community within the region, including the Newcastle Pride Festival, which is running from the 11th to the 27th of October. And we had the Pride Parade last weekend. It was great to see such a large turnout. The Pride Fair Day will be taking place this Saturday, and I'll be very proud to be opening this event. Attended by over 5,000 people each year, these are the events that highlight Newcastle's support for our community. I also want to acknowledge the large contribution from Hunter Gender Alliance in their advocacy and hard work on this issue, and I know they have been consulting with Alex on this bill. I specifically want to acknowledge the President, Arden Cassie, who is here today in the gallery to witness this historic event. I also want to acknowledge the Vice President, Paige Johnson, and Secretary Joe Mills. Another historic political figure who I know would be very proud today would be the late member for the Legislative Council, the Hon. Paul O'Grady, the first openly gay member of New South Wales Parliament and a dear friend to me, and many others too. The growing support for LGBTQI+ organisations in Newcastle, in addition to Paige's overwhelming Ward 2 results, emphasises Newcastle's impetus for greater policy support and inclusivity. On this point, I would like to bring to the House's attention correspondence I received from Dr. Peter Stewart, the Anglican Bishop of Newcastle, who said to me, "I'm writing to you as the Anglican Bishop in my strong support of the bill introduced by Alex Greenwich to reduce discrimination of LGBT people and others in our community. You may have heard from people who hold conservative religious views, but you will also recognise that there is a wide diversity of views amongst religious leaders and the faithful. You can be confident in your decision making that you will receive strong support for the proposed measures from people who attend churches and other faith communities. My diocese, some years ago, formally adopted an LGBT citizens. We consider that, with others, we've contributed to discrimination against these people. More recently, Equality Australia identified over 500 laws perpetuating discrimination. In March 2022, I was privileged to join with over 150 religious leaders from 30 countries and a range of faiths in a meeting at the UK Foreign, Commonwealth and Development Office to agree to a set of 6 safeguarding principles to protect LGBT plus people from harm. Alex Greenwich's bill is consistent with those principles. In nearly 35 years of ministry and 61 years of life, I've been privileged to hear directly the experience of LGBT people. Their life stories have changed me. They have been diminished by institutionalised discrimination, which has provided licence to others to act abusively. To name just one example, I've been moved by the experience of transgender people who've grown up with others assuming one identity for them based on the sex assigned to them at birth, who then discover a way to be fully themselves. They name the impact of being limited from changing their birth certificate unless they undergo invasive surgery. I commend the bill for your support in the current sitting of Parliament. Yours sincerely, Dr. Peter Stewart. Here we are today to ensure the principles of empowerment, prevention, proportionality, protection, partnership and accountability are implemented into our legal framework to safeguard the lives of our LGBTIQA plus community. It is our responsibility as a government to ensure that our laws support all of our community, and it is for that reason that I support these amendments here today. The Private Members Bill will amend 10 acts: the Births, Deaths and Marriages Registration Act, the Surrogacy Act, the Guiding Principles of the Children and Young Persons Act and Children's Guardian Act, the Crimes, Domestic and Personal Violence Act, the Crime Sentencing Procedure Act. The bill will amend the Drug Use and Trafficking Act and Workers' Compensation Act. It will amend the Mental Health Act. The bill will also amend the Summary Offences Act to remove an outdated offence as well. I'm very proud to be here as the member for Newcastle in support of the LGBTIQA plus community and speak in favour of these amendments to this most historic bill.
I thank the member. I call the member for, what's it called now? Kellyville.